Thanks so much for your time, Dr. Phelps. Is the medevac laws, now that they've been in practice for some months, are they working as you intended?
The medevac laws are working as intended. People who are too sick to be treated on Manus Island or Nauru are being carefully assessed by expert doctors, and recommendations are being made, and their timely transfer is happening as we speak. So there have been around about, I believe, 30 people who've been transferred under the medevac laws. There are a number of other cases being considered, and these are people who would have previously been held up in the courts for a very long time, and there has been at least one death because of delay of somebody who died from, Hamid Karzai, who died from an infection in his leg. And so these laws are working as they intended and should continue to do so.
Of the 30 that have been transferred to Australia under the medevac laws, do you know what kind of injuries or ailments they were suffering?
It's a range of chronic and acute conditions, obviously because of the confidentiality involved in medical cases. It's not possible to speak about the details of individual cases, but certainly the doctors who are involved in these cases have been deeply concerned about the seriousness of the physical and mental conditions of these people who have required transfer. And bear in mind that the reason these people are being transferred is because the treatment is not available for them on Manus Island or Nauru. They cannot be properly treated there, so they must be transferred to Australia for treatment.
Well, Peter Dutton has said that he has no power to refuse people of bad character under these laws, and says that people have come to Australia under the medevac legislation that have a bad character.
Well, the Minister has used the bad character excuse as a reason to stop people getting appropriate medical treatment. And under his definition, we actually don't have a definition, but under his definition, it could well be somebody who tried to get to Australia by boat, which made them of bad character. So there have been appropriate safeguards put into the legislation so that the Minister does have significant right of veto over these transfers if there are national security concerns, or if the person has had a conviction for a serious criminal offence. And these are adequate safeguards, bearing in mind that we have a responsibility as Australians under international law to provide medical care for people, and this spurious excuse about bad character does not mean that Australia fails to have an obligation for people who are seriously ill and cannot be treated under our care, and who are on Manus Island and Nauru.
Do you accept that the safeguards put in place in this legislation, as you just put it, on national security grounds or serious criminal conviction, would possibly not cover people, for example, on Manus or Nauru who have been accused or charged with a serious offence?
Look, I think these are very spurious arguments. The reality is that the people who are on Manus Island and Nauru have been there for around 6 years. Malcolm Turnbull, as Prime Minister, told the United States President that we know who these people are, they have been fully assessed, and that they were safe to be able to be involved in a transfer to the United States. Now, what's changed? Nothing's changed.
Well,
we know who these people are. They've been there for 6 years.
Hundreds of people have been rejected by the United States on a number of grounds. Do you accept that those that have been rejected by the US might find their way to Australia and get that pathway because of this legislation?
Well, we'd have to have a look at the reason that they were rejected by the United States, and sometimes it's because they came from a particular country. That the United States didn't want to accept people who were nationals of that country. And so I think we also need to be thinking about why people might have been rejected by the United States who might otherwise be able to make a valuable contribution to another country. Bearing in mind that the medevac legislation enables people to come to Australia, it doesn't enable them to have permanent residency or citizenship in Australia. The idea is that they come here for medical treatment.
Yeah, sure, but
really,
a lot of those patients are injuncting. Once they get to Australia, they tie the government up through the court process and do everything they can to stop themselves from being transferred back to Nauru and Manus. Do you accept that that is the case? Well,
there's no question that indefinite offshore detention on Manus Island and Nauru is causing a lot of the damage that we are seeing in people who are needing to be transferred to Australia. And the treatment of people under Australia's care, confining them in offshore detention with no hope of freedom or safety for the future, is causing a lot of the damage. And
we are talking about two different things, aren't we?
What I'm seeing here is the Home Affairs Minister trying to deflect from the fact that he doesn't appear to have a solution to the fact that Australia is not meeting our international obligations to people seeking asylum and refugees who are being confined indefinitely on Manus Island and Nauru. This is a situation that cannot continue. The Prime Minister of Papua New Guinea, is saying that he wants the camp closed. The situation on Nauru cannot continue. So what the Home Affairs Minister would do well to do is to actually find a solution to this long-term crisis that has been created by the Australian government, and it should ideally be a bipartisan solution which has a humanitarian basis and which meets our international obligations.
Okay, just finally, would you be confident in approving a transfer by only reading someone's file?
This is standard practice. You have to bear in mind that the experts who are having a look at these files are not the treating doctors. If you treat a patient, you need to see them personally or assess them personally. But if you are doing a case review, it's quite standard practice. For example, if you're reviewing a complex case for a court case, or if you're looking at a complex case, for example, if somebody is undergoing a cancer treatment, a multidisciplinary team meeting will assess on the patient's records and on the investigations, laboratory reports, and then make recommendations based on the patient's records and those investigation reports. That is not uncommon practice here in Australia, and it improves quality of care.
Dr. Kerryn Phelps, thanks so much for your time. Appreciate it.
Thanks, Laura.